welcome to this episode of White Collar Coffee Conversations. As a group of forensic accountants who work with attorneys and investigators on cases related to financial fraud, commercial litigation, valuation and damages, and many other issues, we're putting together brief interviews with leaders across the financial and legal world to provide you with insights on work that we're currently performing and a look on upcoming trends. I'm Chuck Torrisi, a CPA with experience in fraud investigations, auditing, compliance program, and white-collar litigation matters. On this episode of White Collar Coffee Conversations, we're talking about the recent SEC press release related to 16 defendants associated with an alleged penny stock pump and dump scheme. Joining me today is Jana Steenholdt, an experienced associate in the investigations and litigation practice at Allen Overy. Jana came to mind immediately while I was analyzing this case, as we've previously published an article related to SEC disgorgement, which the SEC is seeking in this newest matter. Jana, thanks for joining us.
Thank you, Chuck. It's a pleasure to be speaking with you here today.
Jana, I couldn't think of a better person to have this conversation with. This is a particularly interesting case, given the SEC is charging 15 individuals and one company located in various locations, including the Bahamas, the British Virgin Islands, Bulgaria, Canada, the Cayman Islands, Monaco, Spain, Turkey, and the UK. The SEC recently released 3 separate complaints with alleged activity spanning from 2006 to, as they quoted, at least 2020. Can you share some perspective on the international aspect of this case, along with the time frame?
Sure. Well, as you are likely aware, these aren't the only recent cases the SEC has brought involving multi-million-dollar penny stock schemes where the SEC has sought disgorgement. For example, in October of last year, the SEC announced that it charged an issuer, its CEO, and 6 other entities and individuals with participating in a penny stock fraud scheme. There, the SEC alleged that the defendants privately obtained discounted stock in more than 140 microcap issuers and subsequently generated gross proceeds of at least $181 million by reselling the stock to the investing public at a substantial profit. So in some ways, this group of cases follows suit. But what I find especially fascinating, as you pointed out, Chuck, is the global span and time frame here. According to the SEC, the 16 defendants in this set of 3 cases located their operations overseas and used encrypted messaging and a convoluted network of offshore accounts to evade detection in schemes that spanned 3 continents. The global reach is further illustrated by the fact that the SEC was aided by securities regulators and other law enforcement authorities in more than 20 countries and are associated in part with parallel criminal actions announced by the United States Attorney's Office for the Southern District of New York. The director of the SEC's Division of Enforcement, Kabir Grewal, even claimed that the defendants in these actions orchestrated some of the most complex microcap stock fraud schemes ever charged by the SEC. He further said that by locating their operations overseas, the defendants hoped to avoid detection of the massive frauds the SEC alleges they perpetrated on U.S. markets and investors. As people can imagine, an internal investigation of this scope also adds a host of complexities. For example, in contrast to purely domestic investigation, cross-border investigations can involve uncertainty as to whether the information, documents, and witnesses that reside outside the SEC's traditional territorial jurisdiction are nevertheless subject to the SEC's reach. Jurisdictional complexities, data privacy protections, and incompatible legal systems can at times constrain cross-border efforts. But we've seen that this hasn't been a deterrent for the SEC. There is a stated increase in focus and resourcing on white-collar and regulatory enforcement under the current administration, including enforcement that has a global reach. Therefore, it is important for the subjects of cross-border securities investigations to consider the dichotomies in information and access between it and its regulators. I think we will continue to see that careful cooperation and coordination with domestic and foreign agencies is a crucial element to successfully resolving cross-border securities investigations for our clients.
Yes, Jana, thank you for highlighting those points. That was really one of the items that grabbed my attention about this case. The overview and analysis was perfect, very, very insightful. An additional interesting point, which you touched upon, is the allegation that the defendants used various schemes to amass hidden ownership in these penny stocks, promote them, and then sell to unsuspecting individuals. The complaints asked for disgorgement of ill-gotten gains, plus interest and civil penalties. Disgorgement is a fascinating topic. Can you provide your perspective on what amount you think the SEC might be seeking in this claim?
Yeah, well, in its press release that accompanied the three complaints, the SEC claimed that the 16 defendants generated more than $194 million in illicit proceeds. I think the SEC will likely, therefore, go after that $194 million as ill-gotten gains. What will be interesting is to see whether the defendants put forth an effort to account for what they deem as legitimate funds, which we know is a fact-specific inquiry after the Supreme Court's 2020 decision in Liu versus SEC. In general, defendants should offer evidence that both direct and indirect expenses should be deducted from the gross proceeds of the claimed fraud, since the thrust of Liu is that disgorgement's purpose and effect is limited to return of proceeds that the wrongdoer has pocketed, not to return all of the fraud proceeds, including amounts that might have been expended in carrying out the fraud. In addition to disgorgement, I think the SEC will go after large civil penalties as well. During a speech at the end of last year, Director Grewal signaled a determination to consider extracting larger civil penalties for white-collar wrongdoers, specifically stating that the SEC needs to make it harder for market participants to simply price in the potential costs of a violation. In explaining what that means regarding the SEC's approach to penalties and enforcement actions, he referred to a quote from Commissioner Crenshaw in which she said that corporate penalties should be tied to the egregiousness of the actual misconduct. However, Grewal noted that does not mean that the roughly equivalent misconduct by comparable offenders should be penalized in the same amount the 100th time it occurs as to the first. Rather, to achieve the intended deterrent effect, it may be appropriate to impose more significant penalties for comparable behavior over time. In addition, and as you've already noted, Chuck, this conduct is alleged to have gone on for almost 15 years. So that's likely going to be a factor here.
Yeah, I couldn't agree more about the likelihood of seeking large civil penalties, the time frame of the case, and the alleged breadth and techniques used to avoid attention for so long will certainly have an impact. As you know, disgorgement is meant to be an equitable remedy and is supposed to take into account those legitimate expenses. Given these defendants had control over the issuers in question, do you think an argument could be made to reduce the disgorgement amount by some specific expenses?
Yes, in Liu, the Supreme Court held that legitimate expenses must be deducted from a wrongdoer's profits to avoid transforming a disgorgement award into an impermissible penalty. As we've discussed, and you and I have written about previously, the Liu decision provides an opportunity for defense counsel and forensic accountants to argue for meaningful reductions in disgorgement that must be limited to net profits. Arguments can be made that appropriate overhead must be deducted in determining disgorgement. However, I think we will continue to see the interpretation of what exactly constitutes legitimate expenses play out in various court decisions over time. Here, I think a difficulty in claiming the deductions based on legitimate expenses related to the defendant's control over the issuers is the fact that they controlled the issuers as part of the alleged fraud. The SEC claims that the defendants not only hid their control of the issuers through the offshore accounts and the nominee entities they used, but they also sought to hide their control of these issuers by dividing up the shares in separate accounts such that none of the accounts held more than 5% of the issuer's outstanding float. In doing so, the SEC claims that the defendants deceived the public, brokers, and regulators by knowingly avoiding disclosure obligations. So that will be an obstacle to overcome.
Yeah, that's very well said. I mean, disgorgement will always be a fascinating topic to me, but I think you made some really persuasive arguments related to the alleged actions of the defendants and whether or not their control and any associated spend was in furtherance of the fraud, i.e., illegitimate, and can't be used to reduce a disgorgement award. Since disgorgement has been in the news recently, have you seen a lot of disgorgement cases outside of this newest case?
Yes, and I think disgorgement will remain a tool used by the SEC, even if some of the arguments and calculations are tweaked to account for lieu. A recent example of disgorgement that was impacted by lieu is a case called SEC versus Team Resources. That is a case the SEC brought back in 2015 against two California oil and gas companies in the United States District Court for the Northern District of Texas, alleging that Team Resources fraudulently induced approximately 475 investors nationwide to invest over $33 million through the purchase of limited partnership interests in oil and gas wells located in Kansas. In 2018, the district court ordered Team Resources to disgorge over $15 million. After the Fifth Circuit affirmed, Team Resources filed a petition for writ of certiorari to the Supreme Court, asking the court to decide whether the SEC could seek disgorgement as a form of equitable relief for securities law violations. Following its decision in lieu, the Supreme Court granted Team Resources' petition, vacated the Fifth Circuit's decision, and remanded the case to the district court for further consideration in light of lieu. In the renewed proceedings before the district court, the SEC lowered its disgorgement demand from $15 million to just $2.4 million. Team Resources, meanwhile, sought an evidentiary hearing in which the district court could determine what amount should be deducted as legitimate business expenses, as lieu requires. On February 15th of this year, the district court granted the SEC's renewed motion for remedies with respect to that $2.4 million in disgorgement. The court noted that with respect to the determination of proper amounts for disgorgement, the SEC had submitted documentary evidence, whereas defendants primarily devoted their responses to arguing for an evidentiary hearing. The court said that while the defendants quarreled with the SEC's disgorgement calculation, the defendants had failed to support that criticism with any documentary evidence. Therefore, the only evidence before the court on the proper amount of disgorgement was from the SEC. So, what does this all mean? I think we have two key takeaways here. First, there are still open questions following the Supreme Court's ruling in lieu. A couple of those questions include what expenses are considered legitimate such that they should be deducted from a disgorgement award, and does the FCC have an affirmative duty to inquire about legitimate corporate expenditures? Second, defendants will be better off if they are prepared with documentary evidence to support arguments to deduct those legitimate expenses to lower the potential disgorgement amount.
Yeah, that's fascinating that, in light of lieu, they reduced their request by such a significant portion. And it's something that's just going to continue to play out. And it's something that I know I'm going to keep researching, and you will as well. Although we could continue this conversation for some time, I really appreciate you sharing your perspective on these topics. We're so grateful to have you on this episode of White Collar Coffee Conversations, and I just want to say personally thank you so much, Jana.
Thank you. The pleasure has been mine. Thank you very much for having me, Chuck, and thank you to everyone that's tuned in.
We want to thank our viewers and listeners out there for your interest in this video series. If you have a topic you'd like to discuss in the future, please reach out to me on LinkedIn to get connected. Thank you, everyone, and until next time.